have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive.
In this courtroom, excuses collapse under the weight of hard truth. A defendant stands before the judge, but remorse is nowhere to be found. And when justice loses its patience, the consequences turn final.
Any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to go.
I ended up getting in Litchfield one day.
Okay. He indicated that he was only
take your hands out of your pocket.
He indicates that he was only in Indiana for one day. He has been back now.
One day too long.
One day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield,
Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact, and I apologize.
No, you didn't contact everybody you could have contacted. Did you get a response? Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else. He was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not. But the issue is he was on bond for a CCW at the time of this possession case. He leaves the state. And I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are really had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was going to follow the bond conditions that were set by the court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to Community Corrections. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here now.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendant's remanded on the warrant. Community corrections for violation of his bond.
Thank you, Your Honor.
Court calls the case People versus Desiree Badnovich.
Yep, right here.
Okay. Hello.
Rob Chico on behalf of Mr. Bogdanovich. Judge, we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms.
Because she's
Bogdanovich,
correct.
no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they
I
told
mean,
me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
All right, so probable cause conference, I'll adjourn it. I have to go 2 weeks out. I would put it 1 week out, but we have to do the whole writ procedure to get you before me. So I'll go to the 23rd, the next day that I can possibly do it.
That's fine, Judge.
2025 at 9. Bond in this case will continue.
Thank you.
Okay? Thank you, ma'am.
Thank you.
Court calls. Hey, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point, none of
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
Set probable cause, I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes,
my staff.
I suggest we set an exam date.
It's not gonna happen until discovery is all complete. He's saying discovery's not, I'm not gonna do it. What I'm gonna do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set them that way. I'm not gonna set it. I'm gonna hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may like never come because it's passcode
And
protected.
then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's gonna happen, so I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I mean, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where
What
they're,
subpoenas?
No, I didn't say that.
well, is there other notices out there for anything else that you're doing with, other than his?
I hear that there is electronic devices that are password protected that is gonna take some time to get into, that he may have the passwords to, but I don't think he's gonna give them. So we're just gonna have to wait on that. I mean, that's what I'm hearing. Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th.
This case proves one thing. Silence and stubbornness carry a heavy price. When accountability is ignored, the law delivers its harshest answer. In the end, justice always speaks louder than guilt.